Harper Paperbacks and Harper Monahan are proud to present How to Read the Constitution and Why by Kim Wehle. This is an Iliotibial band Sleep's reading. My main YouTube channel is Spleenathon Official. I was going to listen to an audiobook of this book on YouTube, but I was saddened to find out that no such exists. I took it up in my own hands to read this myself. You should know, however, I have been illiterate since 2016. Please bear with me and show patience as I make it through this book. This book is dedicated to Isabel, Caroline, Chloe, and India, my beautiful children. Well, not my children, Kim Whaley's children. How to Read the Constitution and Why. Introduction. This is a book about the Constitution. It is not a comprehensive guide to every provision of the Constitution. It is designed to give you a better understanding of the headline news and analysis that deals with the Constitution. But if you are looking for something that will confirm your side of things politically, you might be wasting your time. This book does not have all the answers. It doesn't summarize Supreme Court cases or even provide a comprehensive explanation of any one constitutional topic. The objective of the book is to begin to teach you how to approach constitutional text, to point out the inevitable gray areas in what has become a very black and white political conversation, and to note how these gray areas arise in the headlines as well as in everyday life. First, what is a constitution? The U.S. Constitution is a document that puts certain things beyond popular vote by making those things clear in writing. It was designed as a machine that lasts forever. For that reason, it is very hard to change. Hate Trump, hate Obama? Guess what? The Constitution was designed for both of them. When it was written in Philadelphia in 1787, it did not contain a Bill of Rights. The people who drafted the Constitution did not think one was necessary. They thought that the structure of the government was enough to protect individuals' rights. The Bill of Rights was added later. The question for generations, therefore, has been whether the framers of the Constitution got it right. In order to begin to answer that question, every generation needs a basic working knowledge of what the Constitution does. It sets up a structure of government and lists individual rights. And what it doesn't do, it does not crown a king. This book helps build that knowledge and also answers questions such as, what are the powers of government? What are the limits of those powers? And what does it mean for the individuals to have rights under the Constitution? Before getting further into what the Constitution says about the government, let's ask another basic question. What is the government in the first place? An easy way to answer that question might be to compile a list. The government includes the President, Congress, and various clusters of people in Washington, D.C., who make and implement lots of rules. It includes state governors, state legislators, and judges too. Then we have police officers, public school teachers, board of election and education, mayors, district attorneys, and city council members. But what does this list say about the definition of government? Looking at the list, we might notice that it includes many people whose paychecks come from taxpayer dollars. Many of them are elected. Others, like the U.S. Attorney General and federal judges, are appointed. Some of them have powers that private people do not. Police officers have the power to throw people in jail if they don't comply with the government's rules. The CIA has the authority to gather highly secret and sensitive information that regular people cannot access. Generally speaking, the government gets to tell people what they can and cannot do. And if people don't comply, the government can impose consequences, usually financial, but sometimes the government can take away an individual's liberty too. Or in the extreme case, it can deprive a citizen of the ability to live on this earth a single moment longer. The government has powers that regular people do not. If a regular person poisons someone else to death deliberately, execution style, she will go to jail. The government, in fact, will see to that. The government's ability to take actions that regular people cannot makes some of us angry. The notion that the government might force a person to get its permission before he can own a gun, or that it might put a woman in jail for terminating her own pregnancy, or that it can make a young man pay a penalty if he chooses not to spend his paycheck on private health insurance can seem outrageously overbearing in a country that was founded on the notion that the government cannot infringe too much on an individual's rights. Why don't those rights include the right not to make a wedding cake for a gay couple, or the right not to have one's taxpayer dollars spent on people who live in the United States illegally, or the right not to have one's tax money spent on nuclear bombs? We put up with all this because the government also does things that make our lives work. Although we don't like everything the government does, we all like at least a few things, whether or not we realize it. We like that the government paves roads and builds bridges so we can get where we want to go, and that it makes and enforces rules that keep known toxins out of our food and prevent passenger airplanes from routinely crashing into each other midair. The government creates traffic rules and puts up stop signs and red lights so that simply driving your kid to school is not a life-threatening chaotic mess. The government makes sure that doctors have the proper training before they cut people open on an operating table. And it takes away that prerogative if doctors hurt or kill their patients. It makes sure that violent criminals face consequences for their actions and takes steps to protect the public from those people. The government talks to our international neighbors and foes around the world, kind of like a schoolyard monitor on a global scale, to protect our national community from invasion. It also makes sure that the money in our pockets has actual value so that we can buy food, clothing, and shelter, and maybe engage in pleasurable things from time to time, even though complicated economic forces could have the very opposite effect. We could go on and on with examples of how the government is both good and bad. Of course, by accepting your government, we do not accept every part of it. Government is more like a buffet. There are appealing items for everyone as well as things to avoid. When we see the government's menu items are good, we are happy and we go about our business. We don't worry much about it or what it's doing, except to the extent that we cast our votes for people who will maintain the status quo. When the government is bad, we get upset. We make some noise and cast votes for people who will change the status quo. But these days, the American system of government seems off. The simple levers of democracy aren't working the way we've always assumed they must. We are not the shining light of freedom for the rest of the world anymore. Lots of things are going on that undermine the governments envisioned by the framers of the Constitution. The framers didn't foresee, for example, a national political process awash in money flowing from super rich people and big corporations, and the resulting need for politicians to incessantly hunt for re-election dollars in lieu of actual governing. They do not foresee that electoral districts would be drawn in such a way that incumbents can be shoo-ins for re-election. They didn't anticipate the explosion of big data technology and how it would forever morph the very concept of the individual privacy. Nor did they expect that technology would open our electoral system to hostile influence by foreign governments. Read Russia in the 2016 presidential election. Yet, perhaps most ironically, the framers did anticipate that deep ideological factions could rip the country apart and leave space for the kind of autocracy that they denounced in the form of the British monarchy. As a result, they wrote the Constitution to avoid a government that could devolve into a purely tribal political system under which certain points of view become more important than fostering the interest of the public as a whole. Today we find ourselves mired in just that kind of political depth spiral. What on earth is going on? The cracks we see in our constitutional system of government derive in part from a largely unspoken but counterintuitive reality that the very concept of government is a mirage. Under the U.S. Constitution, the federal government is comprised of three branches: the legislative, Congress; the executive, the president; and the judicial, lower court, federal judges, and the Supreme Court. Of course, this is all in addition to the state governments, each of which has its own legislative, executive, and judicial systems. The Constitution spells out how the people within each of these three federal branches get their jobs, and for the most part, how they can lose their jobs. But the Constitution does not say that people who attain their jobs in the manner described by the Constitution are the only ones who do get those jobs. Of course the president is the president. He is elected under the terms of the Constitution. Only the members of Congress get to be members of Congress. But what about the job of investigating, prosecuting, and otherwise enforcing laws? The president is not the one who actually does that. Lots of people in his chain of command do it, though. Lots of people who aren't even in the government as we defined it, who are not paid through taxpayer dollars or hired through the electoral process, enforce laws as well. The same goes for making laws. Congress does it, but so do people outside the legislative branch. People in the private sector, lobbyists, and consulting firms make laws too, meaning that they propose what rules should bind private conduct. For example, who should be able to get guns easily, and pass them on for legislators to enact without much knowledge or intervention from the public. If we account for what the people outside the Constitution structure who actually perform the various functions of government, it becomes strangely evident that the government does not really exist as we may assume it does. It is inextricably enmeshed, Bro, I can't define it. I can't tell you how to pronounce it. This is not a real word. It is inextricably enmeshed with the private sector in ways the pages of this book cannot fully account for. Does it matter that the government is not an easily quantifiable entity? The answer is yes. It matters because people who work for the private sector, corporations and think tanks, and lobbying and consulting firms have different incentives than the government employees do. Their job is primarily to make money. The rules of Constitution mostly don't apply to them, and they don't care if they get reelected because they weren't elected in the first place. The voters' needs are irrelevant if they don't align with profit margins. The financial needs of private firms, by contrast, are entirely relevant to what the government does. Private corporations want rules that help their bottom lines and make them more money. By supporting lawmakers in election campaigns, private entities effectively step into the shoes of individual voters. Lawmakers react by making governmental decisions that help their donors amass more money. Importantly, the same holds true for foreign governments. If foreign governments are poised to make decisions for or to exert influence on elected officials, we can be certain that their motives are not fully aligned with the interest of the American people. Let's be clear about one thing. For starters, the Constitution is not bulwark. By this, I mean it does not erect an impenetrable wall around the citizens of the United States to defend them against tyranny and abuses. It is porous. It needs shoring up from time to time. The people of the United States must carefully identify emerging holes and plug them up as quickly and effectively as possible. That task is easier than it sounds. Why? Because the most important thing to understand about answering questions under the Constitution is that it all depends. It depends on what the Constitution says, to be sure, but more importantly, it depends whether or not there are systematic consequences for violating its rules, both expressed and implied ones. Now let me say a few opening words about implied rules. Some social contracts are memorialized in writings. Others function along unspoken terms that ultimately derive from baseline norms and values that may differ from one person to another. If there's enough money and tenacity to get a contract dispute before a judge, for example, the judicial process works only if the losing party is willing to abide by the judge's order. If that party violates the order, the judge must impose consequences for that too. Otherwise, the judge's order, like a contract that goes unenforced, becomes basically meaningless. The Constitution works in much the same way. It is a relatively terse document that leaves much of its necessary terms and meaning unwritten. The Constitution is held up by conventions and norms that developed over centuries of American history. The expectation, for example, that presidential candidates will make public their personal finances, that presidents will enable timely and exhaustive vetting of officers and employees who have access to classified information, that the leadership within the executive branch will be staffed by experienced people with meaningful expertise, that the loser of a presidential election will concede to the victor in order to facilitate the peaceful transfer of power, and that the president will conduct himself in public with decorum and dignity. Likewise, what people consider core American values, such as the opportunity for financial success and upward social mobility, rewards for hard work, cultural diversity, and unrestricted individualism may not be expressed anywhere in the Constitution. These and many others American values are a part of an unwritten social contract. If they are taken for granted or not socially enforced, these values will cease to reign in America. To be sure, a society of individuals, we also subscribe to more of a hard-line concepts of the rule of law. The rule of law is shorthand for the legal rules and standards that we collectively believe are worth having. The ultimate boss in this regard is the Constitution. Below the Constitution, in the hierarchy of laws, are statutes passed by legislators, then rules and regulations issued by administrative agencies, and then decisions by courts of law. The collective assumption and agreement among we, the people, is that we all follow the rule of law, or else. Consider the rule against killing other people. Political affiliations aside, we all probably agree that in order to live freely, a person needs to be able to leave home without worrying about being shot by an angry neighbor on the front lawn. Thus, we have laws banning murder. But the laws themselves only go so far. A prohibition on murder is meaningless if there are no police officers or prosecutors to enforce it, or if a judge's order sending a convicted criminal to prison can be ignored for the right price. Likewise, a routine contract has effect only if the parties are willing to adhere to it in good faith, and barring that, to go to court to enforce through the judicial system. So too, if a federal judge determines that the president or any other elected leader of the government employee has run afoul of the Constitution, the document itself cannot enforce the court's order. If the head of the executive branch violates it, a consequence must follow. Otherwise, the rule of law becomes meaningless. There is no constitutional cop lurking on our democratic street corners who is tasked with enforcing the Constitution. Accordingly, if a provision of the Constitution is not enforced, it becomes worthless. It is kind of like jaywalking. We all do it because there is virtually no consequence for violating laws banning the practice of crossing a street anywhere but at a designated crosswalk. But imagine that one day hidden cameras are installed on certain street corners. The cameras capture jaywalkers red-handed. So people start to follow anti-jaywalking rules on the streets that have cameras, but only on those streets, because no consequences for jaywalking lie elsewhere. Today, the Constitution is at risk of becoming a sort of anti-jaywalking law, something that can be ignored or violated with no consequences. Its vitality is eroding under our noses, but few people realize it. A big reason for this is that most people do not really know what the Constitution says and does, and if they've taken the time to read the document, it is impossible for anyone to understand how the Constitution actually works without some sort of additional explanation. A guidebook of sorts that fills in the blanks left by broadly worded language written more than 2 centuries ago. The Supreme Court fills in those blanks all the time, which is why no one can get a grip on the Constitution today without knowing a lot about Supreme Court cases, as well as other stealthy changes to the document that occur by virtue of the passage of time. This book provides that explanatory guide. It outlines the basics of constitutional structure, theory, and individual rights for lay readers. It explains the sources and limits of power that each branch possesses, and perhaps most important, it describes how individuals within each branch can and should use their respective powers to hold the other branches accountable. Checks and balances, my friends. In addition to teaching readers how to think about the Constitution, this book also walks through many of the what-ifs that are weighing on Americans' minds right now. What if a president fires a special prosecutor charged with investigating possible criminal wrongdoings by his top advisors, or even the president himself? Most of us know that President Richard Nixon resigned under the threat of impeachment in the wake of such a maneuver. So why are we still talking about whether it's constitutional to do it? What if instead of being impeached, the president is criminally indicted? Would the Constitution allow that? Although President Bill Clinton struck a deal with prosecutors to avoid criminal subpoena, he was impeached nonetheless. When does the Constitution call for impeachment, and how does the impeachment process differ from what a special prosecutor does? In the Trump administration, there has been a lot of friction between the Department of Justice, DOJ, and the FBI on the one hand and the president on the other. If the Department of Justice lawyers work for Trump under the constitutional structure, how is it possible that they can become so polarized against their boss? I teach law school courses, and we're talking about Kim Wehle right now, that lay the groundwork for answering these questions. My classes often begin with the following hypothetical. Imagine a presidential election in which the winning candidate promises sweeping reforms. The public wants change: immigration, the environment, jobs, small business, abortion, healthcare, taxes. The president-elect vows to fix all of these by employing skills gleaned from a lifetime success in business. He promises to drain the swamp in Washington, a code for upending the federal bureaucracy with the pull of a plug. Now that he is president, can he actually do it? The answer to this question on the surface seems relatively simple. Article 2 of the Constitution gives the president his powers. Like a cookbook, one needed only turn to the chapter of the executive branch and read the recipe. A decade of studying separation of powers theory has taught me, however, that the Constitution is not a cookbook. It is infinitely more complicated and nuanced. But just like a chef needs to understand foundational cooking concepts, such as the difference between braising and roasting, and how to thicken a sauce, there are a number of critical common sense concepts that undergird constitutional theory. By theory, I mean that the philosophy behind the law, the abstract goals and rationales for American law as a whole, for the specific provisions of the Constitution in particular, the content of legal theory can be mixed with other disciplines. It is different from what is known as legal doctrine, which comprises the basic rules that come out of disputes before courts. Theory is also more abstract than policy, which is about the ostensible reasons and justifications for a law. Basic policy does not delve into the intersections between the cultural and power relationships in society and how they influence the legal system. First, having a cop on the block matters. It is important to grasp something about human nature that drives legal systems. A law is meaningful only to the extent that it is enforceable. In other words, if people who drive over the speed limit don't get tickets, law mandating that people drive at or under the speed limit are not, as the saying goes, worth the paper they're written on. Hide a speed camera on a half-mile stretch of a busy road, and in a short order, the traffic will slow down for that half mile, but pick up again where there is no longer a consequence for speeding, i.e., the dreaded ticket in the mail with a blurred photo of your car's rear license plate. Likewise, any experienced parent knows that rules must be enforced with your kids or they cease to be rules. If you tell a child that no television is allowed in the morning before school, but you need to make a critical phone call one day so you can allow your 5-year-old 20 minutes of TV just this once, the child instantly learns to tune out the no TV rule completely. It becomes ad hoc and optional. Constitutional doctrine and theory is no different. It only is meaningful to the extent that there are active leaders that can be pulled or pushed to enforce its provisions. Second, there is a big difference between policy and politics. I walked into my first year civil procedure class prepared to teach litigation discovery rules on November 9th, 2016, the day after Donald Trump won the Electoral College vote and was met by a palpable sense of collective fear. Many students knew only an Obama presidency and were just beginning to feel a sense of social agency beyond their immediate family and friends. I instinctively knew I had to bring sanity to the chaos without alienating those whose candidate had won. In seconds, my brain constructed a different idea. What's the difference, I asked, between policy and politics? Hands shot up. Policy is the rationale behind a rule, the reasons behind a statute or regulation that governs private conduct. Good. What does policy mean in a presidential election? Silence. Then hands again, timid this time. Candidates have policy views about how to regulate the environment, what to do about health care, immigration, things like that. Again, good. Next question. In this election, how much the media coverage and debate, both public and private, was about policy? Several people blurted out with confidence, none. Nervous fidgeting followed. Imagine you are a policymaker. What kind of information would you want to take into account in formulating policy? I asked. This one evoked nearly instinctive response. We had drilled down on the policy rationales for civil litigation rules all semester long: efficiency, fairness, accuracy. Policy should be formulated in a way that minimizes waste and bureaucracy, is as fair as possible to everyone implicated, and produces accurate results based on empirical evidence. Thoughtful policy makers may debate how to best balance these objectives, which are not exclusive, but they cannot reject them altogether. To understand in simple terms how a policy is made, consider the 65-mile-per-hour speed limit on the I-95 corridor between New York City and Washington, D.C. The 65-mile-per-hour rule is efficient because it establishes a bright line that can be tested with technology that stakeholders agree is generally accurate. Adjudication of violation is relatively easy. A speedometer either clocks a car moving above 65 miles per hour or it does not. The rule is fair because it applies equally to all drivers on the road, but a 65-mile-per-hour rule does not always produce accurate results. In a severe snowstorm, 65 miles per hour may be too fast to avoid road accidents. An alternative rule could be used to drive safely. A drive safely standard would account for snowy weather, requiring drivers to slow down in a storm, but would be much harder to administer. Judges would inevitably have to hold evidentiary hearings with witnesses and consider real-time weather data to determine whether an individual driver was in violation of the rule given the road conditions on a particular day in order to be at a legal speed limit. A grandpa with cataracts would need to drive slower speed than a professional NASCAR driver. There would thus need to be an inquiry into the grandpa's eyesight, whether he mistakenly took medication that made him drowsy, and his driving record, among other questions. The speed limit would become highly fact-specific and individualized. A drive safely rule would give judges a lot of discretion to make decisions that wind up in being consistent and, if unfair, leaving the public in the dark about how to comply with the law. Thus, all things considered, Maryland state lawmakers presumably decided in favor of a 65 mile per hour over a more pliant subjective standard. How then does policy differ from politics? Politics can be confused with policy to the extent that the term political is associated with the activities of the government. Our federal system comprises three branches: legislative, judicial, and executive. I feel like we're going around in circles here, Kim Wehle. Each of which makes decisions based on policy, rationales, and empirical evidence, as well as normative goals and values. But political has another meaning, that it has eclipsed the other in recent months and years. To politicize an issue is to associate it with an ideological basis or viewpoint that may be fiercely guarded by certain clusters of people. When an issue is politicized, ideological bias drives policy, regardless of the merits and the facts. Take climate change. The scientific consensus is that the Earth is warming and that there is a 95% or higher probability that the warming is predominantly caused by humans. Responsible lawmakers on both ends of the political spectrum may debate whether halting this trend is, as a policy matter, important enough to justify the impacts of environmental regulation, such as increased cost of compliance for industry, which may be passed along as higher prices for consumer goods and services. Various lawmakers duly balancing considerations like efficiency, fairness, and accuracy might arrive at very different responses to climate change as a policy matter, without evading established empirical facts regarding the causes of a warming planet. What does this have to do with understanding the constitutional issues arising from the current presidency? There are many things in life that impact us greatly, but we cannot individually control. The election of an American president is one of them. What we can control is how we engage around divisive issues. These days, most law students arrive on campus highly skilled at identifying what they need to know and regurgitating it back to the professor. What I tell students is that this skill will get them a C in my class. People don't pay lawyers if Google has the answers to face their legal questions. To get an A in law school, they need to garner the facts and the law on both sides of an issue, reconcile competing policy objectives, and produce a thorough analysis of rival claims. On a law school exam, the conclusion is often irrelevant. For policy makers and judges interpreting the Constitution as well, what matters most is how they arrived at the conclusion. Did they attempt to reconcile competing arguments? Did they account for all the facts? And did they consider the policy implications for each party or constituent group involved? These steps make up a best practice for solving any hard problem. What I tell my students is that they are learning a skill that they can utilize, model, and teach so that the next election can go differently for a few more people. This distinction between policy on one hand and politics on the other is also critical importance to understanding how the constitutional structure of the government does or should work. Third, once something gets in the government's toolbox, it can be picked up for use at any time. When I was a lawyer, a few years out of law school, one of my first jobs was an associate independent counsel at the Whitewater investigation under independent counsel Kenneth W. Starr. I was recruited by a career prosecutor who was on detail from the Department of Justice to work with the investigation of events that took place in the White House Travel Office. What came to be known as the Starr investigation started in the early 1990s as a probe into failed real estate investments by Bill and Hillary Rodham Clinton. It mushroomed into numerous ethics and criminal investigations relating to the Clinton administration, including one that looked into the firing of 7 employees of the White House Travel Office in 1993, and ultimately the Monica Lewinsky sex scandal. At some point during my tenure there, the question came up as to whether the attorney-client privilege protected the communications between the First Lady Hillary Clinton and the White House lawyers from being disclosed. The attorney-client privilege is a judge-made doctrine or rule that keeps communications between a lawyer and client confidential if they are made for the purpose of obtaining legal advice. The policy rationale for it is that if people thought that conversations with their lawyers could be obtained by an opponent and used against them, they wouldn't talk to lawyers in the first place. The theory behind the attorney-client privilege is something like society benefits if people talk to attorneys when their legal rights and obligations are at stake. The First Lady is not a government employee, that is, she is not paid for her service with taxpayer dollars. Prosecutors within the counsel's office argue that the attorney-client privilege did not appeal to Miss Clinton because she was not a government client. An appeals court later found that the privilege did not protect Miss Clinton conversations with White House lawyers, and the U.S. Supreme Court refused to hear the case, so lower court decision stands. I share this anecdote because it was the first time I grasped the importance and longevity of decisions about the powers of the government. What it means today, for example, is that the conversations between President Trump's government-paid lawyers and his daughter and advisor Ivanka can likely be subpoenaed in a civil lawsuit or criminal investigation without contending with the attorney-client privilege. This debate within the ranks of the independent counsel's office often revolved around questions of the precedent. We want this for purposes of the investigation, sure, but if we get what we want, what does it mean for the future White House? Maybe Republican-led ones. Once the subpoena power was construed to include the ability to obtain this kind of information from a sitting president's spouse, it went in the next prosecutor's toolbox where it remains. A more haunting example of the toolbox phenomenon has to do with the so-called War on Terror under President George W. Bush. Famously, then Deputy Assistant General John Yoo drafted a set of memoranda that defined torture as severe pain associated with death, organ failure, or serious impairments of body functions, accompanied by prolonged mental harm over a duration of months or years. With such a high bar to a torture ban, the memorandum gave the president a green light to conduct interrogations in ways that most people would find abhorrent and abusive. The torture memo was made possible the notorious Abu Ghraib scandal of 2003, involving human rights atrocities by the U.S. Army and Central Intelligence Agency personnel in an Iraqi prison, Around the same time as the torture memos, now Professor Yu authored another memo asserting that presidents have plenary power during a time of war to monitor the communications of U.S. citizens on American soil without first obtaining a warrant. In effect, the memo suggested that the Fourth Amendment ban on unreasonable searches and seizures and the Constitution in general does not apply to the president when the country is at war. The correctness of President Yu's conclusions are a matter of constitutional law, was and remains hotly debated. The torture memos were immediately withdrawn by Jack Goldsmith, who succeeded. Assistant Attorney General J.S. Bybee as head of the Office of Legal Counsel and became Yu's boss under the same Republican president. However, once ideas of unfettered authority to torture or spy on the U.S. citizens without a warrant were put into action, they became part of the lexicon of presidential power. Although Congress has since planned some limits on torture, that presidential power is now in the toolbox, so to speak. So to pull out latter, if a president with a U view of executive power sees fit, as a result, politicians and judges of all political stripes must be very careful about how they exercise power when they have it, because they are setting precedents for those who will hold power in the future. Fourth, strict reading of the Constitution is a myth. I want to unravel the idea that some judges strictly read the Constitution and others do not. Think, for example, about Article 2 of the Constitution, which gives the President his powers. It includes language stating that the executive power shall be vested in a President of the United States of America. Emphasis, mine. Some conservative thinkers argue that this constitutional language is not subject to interpretation, that it must be implemented precisely as written, because it is the intent of the long-dead drafters of the language that matters even today. So, how does one go about imposing the plain meaning of language on current-day disputes? For one, the word shall itself seems mandatory. The president gets executive order, full stop. But that's not the end of the story. The next logical question is, but what does executive power mean? The Constitution does not define it. In searching for an answer, one might use common sense or historical practice. In a dictionary or in the writings of the framers around the time of this language was ratified in 1787. But how to pick up among these sources? Does it matter that presidents today have TV, the internet, and a much larger government to run? What about the fact that the federal government in 2019 serves upwards of 325 million people versus the 3.9 million in 1787? And that we live in a global economy that the framers could not have envisioned. Article 2 goes on to state that the president shall take care that the laws be faithfully executed. Emphasis, mine. Does this additional mandate suggest that there are limits on what the president can and cannot do? Can he ignore laws passed by Congress on the theory that the execution of laws necessarily includes the power not to execute laws? You can see where I'm going with this. There is no such thing as a plain reading of the Constitution, yet the false dichotomy between strict and liberal readers of the Constitution is tossed around among the pundits in the minute someone is nominated for the Supreme Court. It is misleading. Many people take as a given that a liberal or progressive judge subjectively interprets the Constitution as a living, breathing document that it adapts to modern-day social norms, values, and challenges. Judges who consider modern-day pragmatic glosses on the constitutional text are sometimes decried as activists. The critique is that judges who interpret the meaning of the Constitution or statutory text are no longer judging that they are amending the Constitution or legislating from the branch, which they cannot lawfully do under the Constitution because it defines the judicial power much more narrowly. The conservative debate is thus framed as one aimed at keeping judges in their constitutional sandbox and leaving it for Congress to make the laws. The problem with the strict reading of the Constitution mantra is that the words often have different meanings, either standing alone in the context of other words. Consider the Fourth Amendment's familiar ban on unreasonable searches and seizures. We can probably all agree that unreasonable is a highly subjective term. Honking your horn when the car in front of you hasn't moved through a green light for 10 seconds might be reasonable to some people, but unreasonable to others. in New York City, not honking could be considered unreasonable in crushing traffic. In Bottineau, North Dakota, population of 2,300, it might be unreasonable to honk under circumstances that do not put public safety at risk. Likewise, the word search can have different meanings. In 1791, when the Fourth Amendment was ratified, a search likely referred to men in uniform banging down front and rifling through drawers and closets without a warrant. But did the Constitution's framers really consider whether taking thermal images of a person's home to find marijuana growing inside constituted a search? What about trafficking a Jeep with GPS device during a drug investigation? Of course not. Yet in both these cases, 2 centuries and massive technological advances after the amendment's ratification, Justice Antonin Scalia, a notorious conservative, concluded that the Fourth Amendment was violated, i.e., that these were searches, and that they were unreasonable ones. Surely, no framer of the Bill of Rights, which was a reminder comprises the first 10 amendments to the Constitution, had GPS devices in mind when the Fourth Amendment was drafted. So were these decisions made by Justice Scalia those of a stricter reader of the constitutional text or something else? The bald reality is that the words have meanings that are not always clear. The meaning of other foundational documents, like the Bible, the Torah, and the Quran, have been debated for centuries. Why would the Constitution be any different? Its inevitable vagueness is why we have split decisions among the highly skilled, respected, and educated members of the Supreme Court, with some justices reading words of the Constitution or legislation one way and others reading them another way. Conservative judges might apply the plain meaning without revealing their true biases. Liberal judges might admit that the language is ambiguous and argue that it is better to look at the goals of, say, the Fourth Amendment and the reasons why we have it, and then to construe the language in a way that serves those goals, than it is to simply pick a meaning that makes sense to the particular judge reading the language on a given day. We might end up at the very same place under both approaches, but on the liberal side we might have on the table a candid rationale for why one meaning was chosen over another. The truth is that any good judge, and certainly anyone sufficiently credentialed for the Supreme Court, begins analysis of constitutional or statutory language with the actual text. Some constitutional scholars debate this common sense notion, which illustrates why the book leans away from high-minded theory, but oftentimes a document's plain language raises more questions than it answers. Which branch of government gets to pick between 2 competing readings? And if it is the judiciary, how should judges decide which reading is the better one? These are deeply complex and rhetorical questions that law professors and judges have grappled with for decades. An intellectually honest foray into this debate is head-spinning. So when I hear pundits blithely pile conservatives into a happy, plain-meaning camp and liberals into a comparatively subject and progressive reading camp under the guise of honest constitutional theory, I cringe. Good judging, like good governance, requires transparency, reasoned decision-making, and sound judgment. To expect judges not to make judgments is illogical. To pretend that those cloaked with the strict reading mantra are somehow not judging but merely translating English into English is folly. In the world of separation of powers theory, which branch of government gets to resolve such ambiguity, and how, is a central question that the Constitution does not answer. Fifth, American values are not laid out in the Constitution. The idea that American values are not in the Constitution is one that piggybacks on debunking of strict reading of the Constitution. That is extremely important. As mentioned previously, when we think about what it means to be an American, many values spring to mind. They might include concepts like honor, humility, transparency, openness, ambition, hard work, innovation, integrity, opportunity, progress, freedom, efficiency, enterprise, achievement, equality, tradition, respect, justice, fairness, diversity, education, security, leisure, the rule of law, and accountability. Underpinning the American way of life to most people is some combination of these soft values which may not be legally enforceable. A person can't be put into jail for being disrespectful or lacking ambition, for example. But they are brought forth in times of strife and chaos as a clarion call for politicians to make decisions that adhere to shared social values. Many people just assume that these values are contained somewhere in the Constitution or some other foundational document. We have heard of the Equal Protection Clause and the preamble of the Declaration of Independence, which states all men are created equal, but these examples are exceptional. Scholars look for the contemporaneous writings of the framers of the Constitution in order to understand it, and such writings, collectively known as the Federalist Papers, contain discussions of the soft values we expect our governments to live by today, but they are not all spelled out in the founding documents of our democracy. To be sure, some of these values have been enacted into law by Congress through legislation. The Civil Rights Act of 1964, which ended segregation in public places and banned employment discrimination on the basis of race, color, religion, sex, and national origin, is an example that there was a time of the not so distant past that discrimination on the basis of these traits was lawful, morally wrong, yes, but not illegal. It thus may come as a surprise that the values we consider quintessentially American are not always self-executing. That is, you can't walk into court and ask a judge to force someone to do the right thing unless there is source of law affording the right to do so. If someone gives you the stink eye on the subway, you may feel wrong, but there is no law on the books that gives you the right to go to court to get a judge to order that person to stop giving the stink eye or give you money for the pain and annoyance that the stink eye may have caused you that day. If someone punches you on the subway, by contrast, there are laws, state statutes perhaps, as well as laws made over many centuries by courts, what lawyers and judges call common laws, that give you a right to go to court and get money of other sorts of relief designed to make you whole again. There are also laws that allow the government to put the puncher in jail, but no anti-stink eye laws. The same holds true for our political leaders. Not everything we expect of them is required by law. The Constitution is the boss of all laws in the United States, but much of its strength is based on social norms and values that many of us wrongly assume rise to the level of rights of citizenship. But as mentioned before, the Constitution is in fact fragile and porous. Many of these values must come from somewhere else and also be enforced by society. If they are to continue to characterize the American way of life, there is no law establishing them, in other words, and no constitution cop poised to enforce any such laws if they did exist. In today's political climate, we can no longer sit back and take them in for granted. Sixth, no constitutional power is absolute. Because the Constitution contains ambiguous language, it is rare for a court to conclude that a certain enumerated power is absolute, meaning that it is not susceptible to limitation by any other provisions of the Constitution. Take the President's power to execute the laws under Article 2. Some people, like Donald Trump, might take the position that power is absolute, that when it comes to investigation and prosecution of federal crimes, which is a traditional executive power, he calls the shots. Full stop. Think about it. What this posture effectively means is that the president can ignore laws passed by Congress and judgments issued by courts if they in any way impact investigations and prosecutions, which is his exclusive turf. Could he ignore statutes governing wiretaping and order a wiretape on a whim? On this broad theory, yes. Would a court judgment relating to the Fourth Amendment, could he search a political opponent's home out of a bald curiosity? Probably yes again, to the extent that there is no limiting principle to this view of executive power. Even with respect to pure prosecutorial power, the theory espoused by the Trump team and to some degree by President George W. Bush's advisors before them, known in less extreme variations as the unitary executive theory, is breathtaking. What it suggests is that under our Constitution, the president ultimately picks and chooses who gets to prosecute and who does not, including himself. Regardless of the criteria he uses are illegal or nefarious, and those decisions get zero oversight. As a result, he can violate laws with impunity because he can unilaterally decide not to enforce criminal laws against himself. He also gets to decide not to enforce criminal laws against whomsoever he handpicks to flout the law, perhaps at his own direction. An extreme unitary executive view likely means as well that any prosecutions that happen to slip through the cracks against a president's personal judgment could be pardoned on a similar theory, i.e., the pardon power is absolute. In other words, the president is justice. Of course, this theory of absolute executive power cannot be correct. Ignoring a federal court's decision on the Fourth Amendment would elevate the power to execute laws above other provisions of the Constitution, including the judicial power, as well as the Fourth Amendment itself. But from a structural standpoint, it also means that the president could run the Oval Office like a dictatorship or mafia ring. Those people who line his pockets with enough cash can commit crimes, while those who turn him down get prosecuted and potentially jailed. That's ridiculous, some might say. How could it possibly happen? The answer is that on a very broad theory of executive power, the president has unlimited discretion to call off the dogs on himself. So anything goes. Assuming he has physical access to the president, he could empty the federal treasury into a bank account with his own name and get away with it. Pretty soon, the theory must go. We would find ourselves living in a lawless country under a government that looks like an autocracy. Instead, the powers vested in Article 2 must be constructed in a way that acknowledges the entire premise behind the founders' drafting of the Constitution. No more kings! Most other provisions of the Constitution work like Article 2. They are limited. There is the First Amendment, free speech, right? But not if someone speaks through child pornography. There is the Second Amendment, right to bear arms, but not for juveniles. There is a right to be free from unreasonable searches and seizures, but some searches may be conducted without a proper warrant. A court's interpretation of the word unreasonable requires some kind of balancing under the Constitution. So too does much of the constitutional law. Courts look at the various competing policy issues at stake and strike a balance that considers the language of the Constitution as well as macro rationales for structuring the government into three distinct, somewhat overlapping parts. That rationale, in a word, is accountability. Seventh, with law, it all depends. Cue the eye rolls. Of course we all like to get answers, but the fact is that the law is not a calculus proof. A legal question depends on two things: the law, i.e. the rules governing certain conduct, and the facts, the story that gave rise to a particular lawsuit. The story involves at least two parties and is unique. No two car accidents are exactly the same. Sometimes one driver screwed up to cause a crash, sometimes both drivers screwed up, sometimes nobody screwed up. There was a horrible windstorm that caused the collision, and nobody but Mother Nature was at fault. Imagine then a car accident in which the driver of a red car runs a red light and hits a blue car that was entering the intersection on a green light. In this story, it looks like the red car screwed up, but courts want proof before they give the blue car driver any relief. The story alone doesn't constitute proof. Of course, the blue party wants to invoke the court system. She will tell her side of the story on a piece of paper called a complaint. The red car driver will tell his story on a piece of paper called an answer. There will be a period of fact-finding called discovery. Both parties will talk to witness in what are called depositions and collect documents and other information from each other like photographs, police reports, and medical records, and from other sources. Once that is all done, and after a few more procedural maneuverings, the case might go to trial. The blue car party will have to prove that the red car party screwed up, i.e. he was negligent. Negligence is a legal concept that has four parts, each of which must be proven at trial. The red car driver had a duty to drive safely. He violated that duty. His violation or breach caused that car accident, and the plaintiff suffered damages as a result. If the blue car party proves each of these four parts with facts uncovered during discovery, which at trials are called evidence, she can get more money to make up for her injuries. In sum, the law in this instance is made up of the four elements of negligence. The facts amount to proof of this particular story one way or another. Whether something is legal depends on both the law and the facts. The red car driver was negligent if he caused the blue driver's injury. Say, however, that she is suing for emotional pain and suffered caused by the incident. She claims that she cannot sleep and uncontrollably flies into fits of rage. During discovery, the red car driver finds out that the plaintiff has bipolar disorder and is on medication. This is a sad state of affairs, to be sure, and the red car knows he did in fact run the red light, but the blue car driver probably cannot get money from him for her bipolar disorder. unless his red light running caused that disorder. Now consider the Constitution. Whether an action by the government violates the Constitution also depends on the number of factors. Recall the Fourth Amendment ban on unreasonable searches and seizures. To be sure, the FBI cannot bang down on a front door while you are at work and ransack your house just because you have blue eyes and the agents in charge hate people with blue eyes. But what if instead of banging down your door, they run a search of your data online and piece together that you like heavy metal music and that your best friend is a Muslim and that you recently read a Karl Marx The Communist Manifesto? Is that a search? Again, it depends on the facts of this particular story, specifically the use of the internet to get information about someone rather than banging down his or her front door. If a court has considered whether an internet search is a Fourth Amendment violation, there is no law banning such a search. The court will make that law based on the facts of your particular case. This is even though there is a law banning unreasonable searches and seizures in general. Lawyers drive non-lawyers crazy by hedging their answers with tons of caveats. People want to get to the bottom line of questions like, can the president tell his subordinates not to talk to the grand jury on executive privilege grounds? The answer to this one is easy. No blanket of ban applies because the law of the executive privilege does not allow that, but certain information may be protected, and that question depends on the person who is testifying and what she is testifying about. It is a fact-specific situation-by-situation inquiry. The answer is that it depends on many factors. There is usually no answer to is it legal. The Constitution is just 230 years old, a wee babe in the broad arc of human history. It could falter. The drafters of the Constitution knew this. They were deeply influenced by French philosopher Montesquieu. He wrote that when the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty, lest the same monarch or senate should enact tyrannical laws or execute them in a tyrannical manner. This dark proposition is not partisan or an ideological one. The Constitution was set up to prevent any one branch of government from having too much power. Each branch must be made to answer to the other two, regardless of who is in the White House or Congress. If the Constitution's system of checks and balances is allowed to lapse or weaken, another governmental structure will emerge to fill in the gap. And rest assured, it will not be superior to the one that has operated to protect individual liberties and freedoms since 1787, albeit imperfectly. It is human nature to amass power. Now let's get started on excavating the Constitution. And that was chapter 1. No, that was just the introduction. God damn.